Hey there, let's look at the statute of limitations and that look back window together. I found a really good website for it, so I'm going to follow along this and then I'm going to read you the bills themselves. Um, but let's start here. This is from the Herman Law Firm, and it's child sexual assault is a tragic reality affecting our society. In recent years, many states have enacted legislation to address the injustices that childhood sexual assault victims face due to the rigid restrictions of sex abuse statutes of limitations. The California Child Victims Act is changing previous time limits to allow more child sexual abuse victims to bring both civil and criminal lawsuits at any age by hiring a California child sex abuse lawyer, no matter when the abuse happened, to finally get justice and recover compensation for their physical injuries and ongoing emotional harm. There's some quick links. California Child Victims Act, Justice for Survivors. In 2019, legislators passed the CVA in California, which took effect January 1, 2020. This important legislative act extends the statute of limitations for California child sexual abuse survivors reaching adulthood to initiate a claim against their abusers. Before 2020, the law required a survivor of SA to file a lawsuit within 3 years from the date they discovered or reasonably should have discovered that the SA resulted in their subsequent psychological injury or illness. The primary restrictive factor linked to the statute of limitations on SA claims barred a child SA survivor from initiating a suit after their 26th birthday, initiating the suit after their 26th birthday. Of course, studies show that SA, a lot of don't even reveal them or begin to reveal the experience till after they're 52 years old. So more than 2 times the arbitrary cutoff of 26. A combination of egregious injustices against children, including the Larry Nassar imprisonment, the Boy Scouts, blah, 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 made them realize and recognize that they needed to change. Legislators realized the grave disparity in the former law, essentially requiring victims to bring a lawsuit before they reasonably even knew or be able to acknowledge it. Perceiving these injustices, the California legislature adopted AB 218 to encourage child SA survivors to come forward and speak up about their abuse, despite the same taking place several years ago. Advocates pushing for these necessary legal changes celebrate. So, the California Child Victims Act. It widens the definition of child SA compared to the previous law to include sexual assault. This more broad definition increases the scope of sexual offenses against a minor that are actionable, ultimately helping a child SA abuse victim. The act also extends the time limit to the later of 22 years after the minor's 18th birthday, so 40 years old, or within 5 years of the date the child SA abuse victim discovered their psychological injury. So let's say they're 40 years old, then they would have that they go, oh, I've been SA'd all these years. They would have till they're 45. That would be the extent of the law. Most victims of child SA may now file a civil suit, or a prosecutor may bring criminal charges against their abuser or the responsible entity. So that extends the timeline from having to file by the time they're 26 to being able to file by the time they're 40. And if they just realized it by the time they're 40, it could be up to 45. So that greatly increases the time limit to file a lawsuit. Additionally, the California AB 218 provides a noteworthy 3-year look-back window starting January 2020 and ending December 31st, 2022. Now, we've been hearing about this hoopla that Mike Rinder, that he didn't tell anybody because it was December 31st, 2023. And that is true because they extended it for 1 year. There was a 1-year extension that took it to 2023. After the expiry of the look-back window, and if the plaintiff files a lawsuit at or after age 40, the law requires the plaintiff, therapist, and attorney to file certificates of merit stating the attorney has reviewed the facts of the case, consulted with at least one mental health practitioner who the attorney reasonably believes is knowledgeable of the relevant facts and issues involved in the particular action, and concluded on the basis that the review and consultation that there is reasonable and meritorious cause for filing of the action. For example, a 52-year-old survivor now has until December 2022 to file suit against their abuser. This look-back window and related legislation is an incredible win for child SA victims in California. If someone experienced abuse decades ago, they can now file a civil lawsuit and work toward achieving closure. This new prolonged time limit runs out on December 31st, 2022. So it was really important then, because the statute of limitations was opened for those 3-year look-back windows, the 3 years of look-back. However, now you still can take a look at this, and you can still do this from 40 to 45 if that's when you're finding it. If you reasonably discovered it at the age of 35, then you'd have up to 40, and so forth. You can access the full text of the California Child Victims Act here, and I have that opened. Here is the Assembly Bill 218. Let me make sure that is opened. And I'm going to stop this screen. And we're going to open that screen. We're going to hit the share. And let me make sure it's to where you guys can read it. You can. So, Assembly Bill 218. An act to amend sections 340.1 and 1002 of the Code of Civil Procedure, and to amend section 905 of the Government Code relating to childhood sexual assault. This was filed with the Secretary of State October 13th, 2019. Pretty much restates what I said about having to file before the plaintiff's 26th birthday. The bill would expand the definition of child SA abuse. It increases the action for recovery by 22 years. And within 5 years of the date of the plaintiff discovers or reasonably should have discovered that the psychological injury or illness occurred. So the same time laws, existing law. This is for any act arising from conduct that occurred on or after January 1st, 2009. And is there anything in here we need to look at? No, there is one other section that I did want to bring up, and I'll bring that up while we're sorry while I look through this. There was a one of these that states that the look back window. Okay, so let me copy this over. Sorry, we have to play Jumanji with the keyboard here. And I'm going to link all of these documents down in the description after I post this. This comes from, let me open up that page. And stop screen, present, share screen, open. No, we don't want to talk to you. This comes from Arias Sanguinetti, trial lawyers. And it basically said the same exact thing, talking about the look back window, the time extension. There has been extension of the statute of limitations for civil sexual assault lawsuits. Here, I'm going to read this to you again. The statute of limitations determines the time period within which a survivor must file a lawsuit after a sexual assault occurs. Prior to AB 2777, the statute of limitations for civil lawsuits regarding adult sexual assault claims, this is adult sexual claims, in California was 10 years from the date of assault and 3 years from the date of discovery of a related injury or illness. Whichever was later, AB 277 retained these timelines, but expanded them further by introducing the look-back window. A 3-year window. This is breaking news, guys. Let me give you the date of this. I'm trying to find when they posted this. Is it down below? When was the last time they? It doesn't say, but we're gonna call them tomorrow to make sure, because I've seen this. I saw this in another section too, and it was theirs. It was the state's website. So after reading that, AB 277 retained these timelines, but expanded them further by introducing the look-back window. This 3-year window, which runs from January 1st, 2023, this is a new window, to December 31st, 2026, allows adult survivors of sexual assault to file claims for incidents that occurred on or after January 1st, 2009, that had been previously been time barred. You guys, this is really a serious, urgent thing that we need to make sure that this is 100% correct. I'm going to pull up AB 277, which okay, so let me pull this in so we can read AB 277. This is an extension of what we had just read on the 218. And let me bring it into here. Again, having to play Jumanji with the stupid keyboard. But this is too important for me to... So this was brought about November 14th, 2022. This was after that 2019, which the 218 started on 2020, remember? So September 19th, 2022, AB 2777, known as the SA and Cover-Up Accountability Act, which suspends the statute of limitations for civil claims brought by SA survivors who were adults at the time of the abuse. The law goes into effect 2023 and amends the Code of Civil Procedure 340.16. It will impact the businesses operating in California and is expected to generate a sharp increase in SA assault claims, including related wrongful termination and SA harassment claims. So this just kind of expands the definition. So the 340.16 was the original one that the 218 expanded on. For the 18th birthday, 10 years from the last act. The actions were filed on or after January 2019. We read that. AB 2777 amends Section 340.16 to actions filed commenced on or after January 2019 and based, so the 10-year look back to 2009 will not be time barred even if the 10-year statute of limitations has expired, so long as those claims are filed by December 31st, 2026. Here you go, folks. This is state statute. AB 2777. And this created a 1-year revival period. This is the Mike Rinder thing from the 2022 to December 31st, 2023. Again, I will link these forms. I will link these documents. And this is really important news. We need to get this out, you guys. So with that, I'm going to close the recording. And I look forward to any of your comments.